He's considering reassigning that minister, but hasn't yet made the decision finally on which portfolio he's going to assign that minister. On the argument that you can never have any moment in time, fleeting moment, when a minister is without a function, it would mean for that moment that person is not a minister. So and that argument flows from this, that a minister, you can't have a minister without assigned functions. Well, portfolio is slightly misleading, because portfolio suggests it's police, but you could take away an aspect of the policing portfolio to give to someone else, like it happened with energy and electricity in that moment when they kind of. But generally, you don't have situations where a minister is sworn in and you don't know yet what the portfolio is. It doesn't happen. But I submit, with respect, that it would be the height of sophistry to say, legal sophistry to say, 10 minutes ago you were given the appointment to be minister. 10 minutes later you were given functions. There's a time when there was an invalid occupation of office or appointment. With respect, those would be, it might even be a de minimis kind of breach, if there is a breach of that kind.
Just one last question. Mr. Mpofu pointed us to sections 177, 194, with this question of no express provision for suspension. And he didn't argue it, but I think the suggestion is that he cited those two examples where there's express provision for suspensions on the basis of the principle inclusio unus est exclusio alterius. That's what the implication is. What do you say about that argument?
There is a reason why those presumptions are only guidelines for interpretation, because there are circumstances when you depart from them. If that argument was correct, Masetla would have been decided differently, because in Masetla you had the power to appoint and you didn't have a power to dismiss. But there are many places in the Constitution, at least the one we are dealing with today, where the Constitution expressly confer a power to dismiss. Only argument is where the Constitution wants you to have a power to dismiss, it says so. You can't imply it where it is not said so. But Masetla went exactly the opposite direction. So it is simply, that expressio unius is simply a guideline for interpretation. The ultimate question that the court has to grapple with is whether we are correct to say the proper exercise of the power to dismiss implies the power to suspend, to enable a when I argued the point, the argument we make is this, is that the President has the express power to dismiss, but that power is constrained under the Constitution. It must be exercised rationally, meaning both in respect to reason, substance, and process. When the President is confronted with allegations and he says, I can't properly inform myself whether a dismissal is appropriate. I can't properly exercise that decision rationally because I'm not sure whether these are wild allegations or there's substance to them. If he goes ahead and dismisses, that with respect is not a proper exercise of the power to dismiss in that context, because it is either irrational for substance or maybe attacked for irrationality for process. So for the President to properly exercise that power, he must have all the powers, implied powers, that enable him to exercise that power consistently with the Constitution. And that means consistently with the requirement of rationality, the requirement that he can't do so in breach of the Bill of Rights. All of those constrain that power. We're not in a prerogative. My learned friend, Mr. Katz, is 100% correct. We agree with him. This court has said so. This is not a prerogative, it's a power subject to constitutional constraints. And when one reads the reach of that power, one reads it in the context of those constraints. And that is where this power is clearly so implied. It really beggars belief that my learned friend can say, if a minister requests to be placed on special leave for any reason, because the reason doesn't matter, it could be a cancer patient, it could be an accident at work, it could also be like former Minister Kize, that there are serious allegations, please place me on leave so I can pay attention to these allegations and defend myself. Could be just a selfish reason for why he asked to be placed on leave. He says you can do it if he asks, but you can't do it if you offer it to him and he accepts and you place him on leave. That's, with respect, makes no sense. And that is in reality a concession that there is naturally a power that arises from the power to dismiss. And we've argued the power to assign and unassigned powers as well as an additional point.
Just one question from my side, Mr. Maneche. Mr. Mpofu this morning relying on Law Society, and in particular I think paragraph 3 thereof, to the extent that he argued that public power must not only be exercised within constitutional bounds, but must also be exercised in the best interest of all our people. And he expanded on that principle, and I understood his argument to mean that when one subjects public power to scrutiny, then it would be competent for a court to decide whether the public power is exercised in the best interest of all its people, which would be a standard different from a legality standard or a rationality standard, but almost looking at the merits of the exercise of that power. What do you say to that? Do you accept that that's a legal standard, or would you say that that may be aspirational in terms of the kind of value-laden society in which we live?
Yeah, it's not a legal standard. Legality is sourced in the rule of law in Section 1C. We don't know where the public interest is sourced in as a standard. But the public interest criterion, forms part of the president's, could form part of the president's considerations when he makes the judgment call whether he must dismiss or not dismiss, for instance, in the present case. But when he's done so and he's challenged and he says, I did it in the public interest, the rationality standard will ask whether, in fact, there is a rational connection between that reason and what he's done. But it's not the court being invited to assess the exercise of the power and saying, just as a decision, first instance decision maker, is this decision in the public interest? No, that's taking over the power of the president and not assessing it for rationality.
Something that's bothering me. I just need clarity. Minister Mkhunu has been placed on special leave. He is still a member of parliament.
Yes.
Still enjoys the benefits. If, I don't know now, the maximum number of members of parliament is supposed to be 400. If that number is 400, inclusive of Minister Mkhunu, and the president appoints Professor Kashalia on the 1st of August. Professor Kashalia is supposed to be a member of cabinet and a member of parliament, isn't it? Would he not be in excess?
I'm not sure that sorry, let me just check that. But I didn't read the constitution to require him to be a member of parliament also.
For instance, when the late Minister Pravin Gordhan was appointed as a Minister of Finance, he was from outside of Parliament. He became a member of Parliament after his appointment. So why would this be different?
Yes.
So once you're appointed as a minister from outside, you become a member of cabinet, and we know that members of cabinet are members of parliament.
Yes. Can I? So the section 91(3)(c) says he may select no more than 2 ministers from outside the assembly. And presumably he can appoint me. I'm not a member of any political party. I'm not sure how I would become a member of the National Assembly, but
He may appoint you, but there must be a vacancy inside the House for you to be a member. Otherwise, there's going to be an excess somewhere, somehow.
yes, well,
And if Minister Mkhunu is still there, then that is the
that's the
problem.
problem. Let's assume that to be the case. I'm not certain about the legal position, and I don't want, perhaps my learned friends here will assist me. Let's assume that to be the position. That would not be a national executive problem. It's a parliament issue to resolve. Because it is parliament that decides whether Minister Mkhunu must carry on as member of parliament despite the allegations, or what happens to him. That's an issue that is not put squarely at the president's responsibility under Section 91. He appoints from outside parliament. Presumably, he'll engage his party, and some other person might choose to resign from parliament. And if we've seen it, especially with this political party. That's
Is
taken
people
noise.
doing this? Otherwise, we'll ask you to leave the courtroom.
Yes. What I'm saying, Justice Mkandla, is that it would be a parliament issue, but there's probably scope for how political parties resolve this. We've seen parties remove people so that, as Justice Mkandla raised with Minister Godan, so the space is made for that person to take up their position and then become a minister. There's also a possibility that those instances happen when the president has exhausted the 91(3)(c) situation, because that's limited to 2 ministers. If I recall, the Minister Patel was also a minister appointed under this section. And there are many, truly, these facts are not before the court, so I'm not able to deal with them directly. But what I'm suggesting is it wouldn't impugn the appointment under 91(3)(c), because all that allows the president to do is to appoint from outside. If he hasn't exceeded the maximum, he is entitled to do so. How, after the appointment, and it will be a matter that arises after appointment, not today, as we argue the case, that issue doesn't arise yet. We don't know whether the ANC has its full complement in parliament or not, and who else might want to step away for Professor Kachalia to take up position. We just don't know. So it wouldn't be a basis on which this court could impugn the appointment of Professor Kachalia. And it's not relied upon by the applicants. Yeah, I know, yes, Justice Mkandla, I acknowledge that.
Justice Majid?
Quick follow-up. It's not proper for judges to answer questions from other judges, but the way I read it, 91(3)(c) is very specific and must be read with 91(3)(b). See, 91(3)(b) says he may select any number of ministers. And we know there's no cap. There's a complaint the cabinet is too big, but that's another story. Any number of members from the assembly. But the 2 he selects is from outside the assembly, and ergo, they're not going to become members of parliament.
Yes, that was my understanding.
Yes. Thank you. So, Mr.
And
Mkhunu,
section 46(1) of the Constitution says,
sorry, which section?
46(1). 46(1) of the Constitution says, the National Assembly consists of no fewer than 350
Yeah.
and no more than 400 women and men elected as members in terms
Yeah.
of the electoral system. So if you're not elected, you can't
Yeah.
become a member. So that would seem to be the answer. Yes, thank you. Thank you. I knew that my resourceful team would come to my rescue.
Manage. Mr. Wadan?
I was hoping for a question on the Commission of Inquiry.
Well, there's none.
There's none.
Mr. Madonsela?
Let me just make sure that I don't leave things for Mr. Madonsela here.
Justice Mhlantla and Justices of the Constitutional Court. Sunday, the 6th of July 2025, will live in memory as a day like no other day, when the Lieutenant General Mkhwanazi, the whole Provincial Commissioner of KwaZulu-Natal, pulled a surprise move without a warning shot and took to the podium and publicly indulged in a most serious attack not only to the law enforcement agencies, the prosecutorial services, intelligence services, the judiciary, all levers of power in the administration of justice. Of course, the Minister of Police himself was not spared. He was also ambushed with this media conference because he was also in Fryhead attending to his political commitments in the by-elections there. The President, too, the second respondent in this case, was in Brazil. And in the wake of these attacks on the minister and other agencies and the judiciary in particular, the MK party drew out, crying out, "Crucify him, crucify him." That's what they said when the president arrived. They said, "You must dismiss the minister." And in fact, in their founding papers, that's the case they made out. If you look at paragraph 25 or 52 at page 24 and 52.6, saying that the Minister Mtuni should not have been placed on leave, he should have been dismissed. That, in fact, was their demand in a letter of demand at page 44, where they said, with reference to another minister, or the Deputy Minister Whitfield, they said the President should have dismissed Minister Mtuni as he did with the Deputy Minister. So that was the case they made out. In reply, at page 236, paragraph 90, they repeated that claim. They said the minister should have been dismissed. He deserved to be dismissed, as it happened with Whitfield, at paragraph 90 of the replying affidavit. It was in this context that the President, after consultation with the Minister Mtunu, and you'll find this in the answering affidavit at page 172, paragraph 12, where the Minister says that I was consulted by the President about this, and he confronted me about the allegations were made by General Mkhwanazi, and I denied wrongful conduct on my part. And that, under those circumstances, the President said, I couldn't resolve the issue. I'll place Minister Mtunu on special leave. May I just ask Justice Teron touch on the point that you raised about what is the nature of this action? Was it leave or suspension? Well, the applicant said in their founding papers, at paragraph 52.1, they said this is just suspension by another name, a fancy name for suspension. And we embrace that characterization. And we embrace it because there is judicial support for the fact that special leave, which is consensual or under the circumstances such as the present, is nothing else but a euphemism for suspension. So when we use the word suspension of the minister, we're using it in the sense that it is a special leave which is a euphemism for suspension. And Minister Mtunu, at paragraph 13 of his answering affidavit at page 173, accepted the decision to be placed on special leave. So it's consensual. So it doesn't matter whether it was requested or granted, but it is mutual between the two of them. So nothing turns on that point. So, my Lord, under this, Justices, under these circumstances, then, we seek to engage with two issues only. Whether the President had the power, the ultra-vires argument, had the power to suspend Minister Mtunu. And in this regard, we locate that power The second point that we deal with is rationality, but my learned friend has dealt with it. I'll just make a few comments in relation to it. In relation to various, whether the minister or the president had the power, we rely, as we do in paragraph 25 of the answering affidavit at page 176, locate the power of the president to suspend on section 91(2). And we say that section 91(2) has three components. The first component is that the president can appoint at the beginning, and in the middle, he can assign. If I may pause in the middle for a moment and go to 98 and say, again in the middle, 98 tells us that he can also reassign the functions if the cabinet minister is temporarily out of action or is absent, temporarily absent. And at the end,
Whether you are buying or selling, find your happy place with Auto Trader.
now the argument today is that, well, because those three parts of 91(2) did not contain the word suspend, therefore it cannot be, it's not an express power or it's not implied power. Well, we assume that our premise for the argument is that, yes, there is no express power, but there is an implied power. And we have placed reliance in the judgment of Ramaphosa in this regard, which is set out at page 50 of our heads of argument. And Justice Konapen, you're right when you referred our learned friend in this regard to the judgment, to the quotation in Baxter in Ramaphosa, where the court said an implied power can be power that is reasonably required in order to exercise the original power. It can also be an ancillary power. It can also be an incidental power. So when you imply powers, you imply those that are ancillary, incidental, or reasonably required. And that's the quotation from Baxter is set out at page 21 of our heads of argument, paragraph 60. And it's also referenced in Ramaphosa itself. So we say in this regard that the implied power to dismiss is an ancillary power, to suspend is an ancillary power to dismiss. And in this particular context, it is necessary to preserve the integrity of the investigations which the president has put and set in motion. And the president explains this in the answering affidavit at paragraph 40 at page 85, where he says he wanted to ensure that there is no interference by the minister or the investigations of the contested allegations that General Mkwana has made in that dramatic media conference. So the power, justices, is implied, is there. It is implied, it is necessary and required in order to exercise a determination on whether or not, subject to the outcome of the investigation, Minister Mtunu should be suspended or should be dismissed or should be retained. So that is the necessity of the power. So, my Lord, we say that in support of this implied power, there is both judicial and academic support for the proposition of an implied power. Insofar as judicial support is concerned, we place reliance in the judgment of MKP, which is referenced at paragraph 61 of our heads of argument, page 24. It's MKP versus the government of the Republic of South Africa. Now, my learned friend says, well, this judgment is not on point for the reasons which I'll deal with in a moment, but here is the reasoning of the judgment. Here is the reasoning of the judgment at page 930 of the judgment itself. Now, this is a case involving the Premier of the Eastern Cape suspending the MEC, and we say that is comparable with the President suspending the minister, said that the other one is in another sphere of government. In relation to the issue of suspension, the judgment says, judgment of Heath, I agree with the principles referred to by Madlanga. Mr. Madlanga was then counsel and is now the commission in the Madlanga Commission. But then he says, however, the Constitution itself already makes provision for the termination of membership of a member of the Executive Council, which is much more far-reaching than a suspension, and effect must be given to the Constitution as far as the power is concerned. In other words, it says there is power to terminate, but there is no power to suspend. But termination is far more far-reaching than suspension. And then at the end, in the next paragraph, marginal letter D says, on the one hand, a suspension is a well-known interim position or a step or a phase leading to a termination or dismissal. And a suspension in the present instance is clearly a logical and necessary consequence of the powers conferred on the Premier. The logic of the greater, including the lesser, therefore applies. In other words, it says, if you have got the powers that are greater to dismiss or terminate, that includes the power that is far lesser, the power to suspend. There is authority for that proposition. So my learned friend says, well, the problem is that the Constitution as it now stands, it gives it in chapter 5, delineates instances where the power, or the acting powers can, in chapter 5, there will be powers that are acting for acting president as distinguished from the powers, the absence of the powers of the ministers to act. Well, my lord, there is a short answer to that argument. The reason why there is a different section for acting president is that in this country there can only be one president. Not many, unlike the ministers who can be many. But the second distinction is that chapter 5 analogy is unavailing, because in chapter 5 you will see when you read the schedule for the oath of office of the president that it is different from the oath of office taken by the ministers. So there has to be a separate system regulating acting president as opposed to a system regulating ministers. So the point is, the chapter 5 argument that there can be nothing in between, because chapter 5 separates or provides specifically for acting president and not necessarily for acting ministers, is unavailing. So, my lord, apart from the judicial support, there is also academic support for the proposition that the power to suspend a minister is inherent or ancillary to the power to dismiss. You'll find this in Closer, in chapter 18, at page 29, which is referenced paragraph 60 of our heads of argument, where the learned authors of Closer say that the power to suspend is an incident of the power to dismiss. So we both have academic as well as judicial support for the proposition that the power to suspend is there in section 91(2). But there is another reason why the power is there, and it's section 98 of the Constitution, which says that the power to assign functions of one cabinet member to another during the latter's absence is implied by the president. So, Justices, you will see that section 98 says, during the absence of one of the cabinet members, the president may assign a function to another cabinet member. Now, the fact that he can assign in the absence of another cabinet member means that there is implied provision that he can create a vacancy and excuse a minister from being present in order to assign another minister. Especially dealing with a particular scenario where that minister is temporarily absent, not because he is not around or he's been reassigned to another post, simply because he's temporarily absent. So if the power to assign a minister during the temporary absence of another minister is catered for in Section 98, that implies that he has the power to create a situation, to allow a minister to be away for purposes of reassignment of another minister. So it is an implied power set out in Section 98. So on those two provisions, we say that there is clear authority for the proposition that the power to suspend is implied from both Section 98, 91(2), as well as buttressed by Section 98, which provides for the power to assign during the temporary absence of a cabinet member. Well, there was some mention in the argument by our little friend, Mr. Mpofu, about the relevance of the Mwabe judgment that the president publicized in a media statement that he was going to appoint Professor Kachale. Now, I was part of Mwabe in this court, and Mwabe is no authority for the proposition that a public announcement alone achieves finality in the decision. I know so because if today Kachala was to approach this court and say to this court, please give me the position that you announced to me because you announced it, he will not get it. That was the result of Mwabe. And finality is achieved, contrary to what my little friend says. Finality is achieved, and this is set out in paragraph 56 of the judgment, not after public notification, but after personal notification, through a minute by the president, concluded and entered in terms of Section 101 of the Constitution. So Mwabe does not assist them to say that there is a problem with the appointment of Professor Kachala. There was just a passing comment in relation to Kachala because that's not my argument. My argument is on there is power to appoint or to suspend a minister. Now, that concludes the argument on ultra vires. On rationality, my little friend has really made the point. I want to make few points on it. The test is well known in the Menzies Milana case, set out in paragraph 65 of our heads. The question is whether the exercise of power, that is the power to suspend, is rationally connected with the purpose for which the power was conferred, and the purpose is to assign powers. Now, the justification for the suspension is set out by the President in paragraph 40 to 42, and there are 4 reasons why the President adopted the route of suspension. He says in those paragraphs, 1, just because of the seriousness of the allegations by Lieutenant Mkhwanazi, whether Mkhunu was engaged in criminal activities. That was the first reason. Secondly, the allegations had profound implications for public confidence in the executive. Thirdly, the need for proper investigation into the veracity of the allegations through a judicial commission of inquiry. Fourthly, that the decision to dismiss Minister Mkhunu was going to set a bad precedent which would be created if the minister was to be dismissed on mere allegations which can turn out to be unfounded at the end. So these are rational reasons we submit, Justices, which led the President to take the decision to suspend rather than to dismiss. And the context is that he had consulted the Minister of Police, our client, and those allegations about him were denied and had to be investigated, as are the allegations that the judiciary was also was implicated in cartels, drug cartels, as are the allegations that the law enforcement agencies are infiltrated, and as are the allegations that there is interference by the minister with the workings of the political task team. So the rationality, my lord, the rationality threshold is met in the reasons advanced by the President, and the rationality is not really about the questions which the other applicants are raising, whether it is appropriate to take that decision, whether it's reasonable to take that decision, whether there are other available options, and we have set out why those considerations do not apply here. And if this court is with us on those rationality arguments, and therefore the application should be dismissed.
Mr. Matonsela, any questions? Looks like there are no questions for you, Mr. Matonsela. Thank you.
I
I think you should run before colleagues change their mind. Mr. Mpofu, tell
Giving him leave of absence. Giving him leave of absence. Thank you, Justices. Maybe let me, well, first, the deal that we discussed with Mr. Katz is on.
the 5 minutes.
No, all of it, the 10.
Whole.
10 plus 10.
So it's 20 minutes.
Yes. Thank you.
You confirm that, Mr. Katz? Thank you. 20
Thank you.
minutes.
Thank you.
you.
So, okay, so I'm going to make sure I've got, let me take off my watch. Oh, there you, thanks. Yeah. So that at least by the time that 20 minutes elapses, I must have said everything I want to say. Let me do this, Justices. I'm going to resist the temptation to start with the point that was donated by Mr. Matonsela based on Mngcwabe, tempting as it might be, because I want to approach my argument differently this time in reply. We, and when I say we, I mean respectfully, I'm including the court, discussed in detail the issue of implied power, and vires and all that. But in my respectful submission, we did not deal with the rationality issue sufficiently. So with the leave of the court, I'll start with rationality this time, so that even if I run out of time, then on implied powers and vires, then and at the back of what I'm going to say, also which might also save us time if we do reach the issue of implied power, is what I said in response to Justice Rogers, which is that there's a clear overlap between the so-called necessity test and the rationality test in the manner that I've explained. So let's go to rationality. And as I say, whenever I deal with this, let's also keep in mind this question of necessity. So what do we have here? Mr. Manager is really telling us this, that the decision to place on leave of absence is rational or rationally connected and linked to the stated purpose. Remember, what is the stated purpose? The generous one that I'm going to grant them. The stated purpose is that this is leave of absence, suspension, call it whatever, pending the outcome of the commission. Right? The fallacy of that argument, to show that there is no rational connection conceivable between the leave of absence and the outcome of the commission. We have evidence, live evidence, that this president will irrespective of the outcome of a commission, will not only appoint you to be a minister, but actually promote you if there's an opportunity for doing so. Let me explain. Because for that argument to hold, it must be that really the president is saying, I don't know about these allegations. I must await the Madlanga Commission. If it says there's prima facie evidence, then I may dismiss. We must believe that story. Well, that story, there's no South African, nobody who lives in this country who can believe that story. No one. Because, and the president says, the reason why I'm taking all these steps is because the allegations are untested. So they'll be tested where? In the Madlanga Commission. But that is a fallacy. Because when the allegations against certain ministers were tested, and this is in our replying papers, those allegations were now tested in the Zondo Commission. And those ministers were said to be prima facie criminally liable. The thing that he says he's waiting for in relation to Minister Mchunu, when that happened, the president appointed those people to be cabinet ministers. And the live example of that is none other than Minister Gwede Mantashe. Let's call it the Mantashe test. The president, to sustain that argument, would have to pass the Mantashe test. And he fails it dismally. Because, as we speak now, today, despite the tested allegations that were in the Zondo Commission, what did the president do? He has appointed Minister Mantashe as acting Minister of Police now, today, as we speak. What does that mean? It means if Minister Mchunu were to be placed in the same position as Minister Mantashe in 3 years' time, after the Madlanga Commission finishes its work and the review applications and the appeals and all that happens, then we would have, let's assume then the Madlanga Commission says Minister Mchunu has prima facie criminality and so on. So he would be in the exact same position as Minister Mantashe now. And we have had evidence that that would mean he would be qualified. In fact, not only has Minister Mantashe been appointed as Minister of Minerals and Energy, and now appointed as acting Minister of Police, he has even been promoted to acting president recently. So if you do wrong and you are found by a commission to have possible criminal liability, not only are you not going to be punished, but you are going to be promoted, probably. What is that? We cannot, this president, I know he can do no wrong, is the super saint. But there has to come a time in this country where we must say, this far and no more. You cannot have a president who's going to come to this court and say, in open court, daylight, I am waiting for these things to be tested so that I can possibly dismiss. When all the evidence shows that with Minister Mantashe, with Zizi Kodwa, with Deputy Minister Mahlobo, all the people who were implicated in the Zondo Commission have been appointed by him. Now, he says the allegations are untested. Well, all of us would love to be in this university where you can't fail. You can't fail the test. Because the more you fail the test, the more you're going to graduate. And we call that rational? That we are all, the whole country must wait for 3 years and spend 2 billion rand to get to a stage where nothing is going to be done. Or if something is going to be done, it's probably going to be a promotion of Minister Mchunu. That is the reality. That is how we must approach the rationality test in this case. Now, once you remove the facade of the artificial connection between the outcomes of the Madlanga Commission and the so-called leave of absence, then its rationality goes to the dustbin. It is simply an excuse to make sure that Minister Mchunu continues to have his salary. Mr. Katz put it properly. The only purpose, I'm inviting anybody to think of any other purpose that is going to be served by the leave of absence, apart from making sure that Minister Mchunu retains his salary. What is it? There isn't. And that can never be a rational purpose for exercising presidential powers in any country. Now, Mr. Mainache tells us about, he dealt with the rationality. I think one of the justices asked the question about the dismissal or non-dismissal. Let me put it like this. We all accept, just so that I'm not misunderstood, we all accept that generally speaking, the rationality test is not what one of the parties, I can't remember which one, accused us wrongly. It's not a whataboutism. So you don't say, okay, well, I suspect it was Mr. Madonsel. You don't say that, well, you placed him on leave. Why did you not dismiss him? In general, you don't do that because it has been said many times in pharmaceuticals, in Albert, in all the cases. But this is not, when we talk about the dismissal of Minister Mchunu in this particular case on these facts, it's not in that mold. Their own version is that this power to place on leave of absence is derived from the power to dismiss. Right? That therefore means in this, on their formulation, you can never take the decision to give leave of absence without having first considered the decision to dismiss and discarded it. So it's not the whataboutism mold. It is to say, because you are saying that power is, someone was even saying a lesser power or whatever. But its parentage, its ancestry is the power to dismiss. So before you do leave of absence, you must have at least taken a decision to retain or a decision not to dismiss. And it is in that context that we say that prior decision is about the breaking of the egg and the omelette. That prior decision not to dismiss was in its own right irrational as well. But if its corollary, to quote my learned friend, is to retain. The president would have been within his right, by the way, and I said this earlier in my address, to retain, to say, after the discussion apparently, to say, yeah, okay, from what you're saying, I'm keeping the minister and I'll wait for the outcome and if he's found to have done something wrong, I'll dismiss him or whatever. He could do that. That would have been a rational, it would have been not a nice decision. Many people would be aggrieved, but on the rationality test, he would be prepared to do it. Now we are told by the president that there's no such thing as the prerogative. Latching on Mr. Katz's, shall we say, overstatement. I'm trying to, because he's on my side, to make sure that I don't. We know this thing about the prerogative is actually very simple. Hugo gets abused, and I probably am guilty of this as well in other instances. Hugo simply says that we don't have the royal prerogative. Everyone knows that. But we have what is called, what I call, and it's actually my own term, yeah, I call it the qualified prerogative. In other words, you still have to pass the rationality test. But there are powers that are the sole preserve of the president. But what is really said is the president who can speak with both sides of his mouth and comes here via his counsel to say there's no such thing as a prerogative. But if you go to page 159, that's annexure, annexure AAA5. You hear, it says the heading, statement by President Cyril Ramaphosa on the removal of Deputy Minister Whitfield. So this is his own statement, the same as when his counsel speaks for him. It says at paragraph 160, after he criticizes, well, first of all, he starts with in this court he makes the false statement that Mr. Whitfield admitted his transgression. That's false. There's no nice way of putting it. Because in his own statement, he says Mr. Whitfield and Mr. Steenhuisen were distorting the facts and what have you. So if they admitted guilt, what was it that they were distorting? But that's not even the point. The point is that he says at paragraph 1, 2, 3, 4 on page 60, given all these circumstances, there is consequently no reasonable grounds for Mr. Steenhuisen and the Democratic Alliance to issue ultimatums and threats when the President exercises his constitutional prerogative and responsibility. This is the person an hour ago who said there's no prerogative. And then further down, it says, it is unprecedented, this is now President Ramaphosa speaking, it is unprecedented in the history of our democracy that the exercise by the President of his constitutional prerogative and responsibility with respect to a clear violation of the rules and so on and so on. So when it suits the President, there is a prerogative. When the shoe pinches, there is no such thing. And just for the sake of completion, page 259, there's an interview done by the spokesperson of President, who was in the position of Mr. Maneche, also speaking for the President. He says at 259, he's asked by Ms. Naledi Moleo of Newsroom. I think the big question is what do you call the straw broke the camel's back? Was it Friday when the minister filling out account before the portfolio committee and so on? It says, well, the people can opine, and when the president can exercise his prerogative, and when can the president exercise his decision? But I think a couple of factors, and further down says the second thing, even in the exercise of the prerogative, anyway, the point is made. The point is simply that everyone knows that when we say the prerogative, and to the credit at least of the president, we all know that means what I call the qualified one, where rationality is at play. But now those statements are being disowned. Now, if there's one thing I have to say is this: the use of the word dismiss in this context, not the use, because it is what it is in the Constitution, but the flawed understanding of that word dismiss is what is really at the center of this case. Because everybody, all of us as lawyers, I suppose, instinctively, when we talk about dismiss, we think about the dismissal of an employee, dismissal of a school principal, and so on. But this is not a dismissal of that kind. This is a removal. This is a withdrawal of someone from the cabinet. And that is why the section on this, section 192, section 92 that we all been talking about, 91(3)(c), uses the word select. Right? So, the power to appoint, obviously, that's the formality. But this language is used advisedly. 91(3), the president must select the deputy president. The president may select any number of ministers, and the president may select no more than 2 ministers from outside the assembly. So what is happening when you, quote-unquote, dismiss a minister is not all these big things about you must prove a case and what if they... It's just a simple matter of deselecting. You are simply deselecting that person. You are not punishing them. You are not impeaching them. You are not doing anything. Just as when you select them, they don't say, well, there should have been an advert.
Insurance is easier when you're naked. Here are 5 things you can do on the Naked app. You can cover your stuff.
And an interview. No, you select them. And just as you must select them easily without having the formalities of employment, you may equally deselect them. And that, yes. So that is those are the points that I want to make without interruption.
So that's it, Mr. Mpofu.
Well,
unless there are questions.
Yes.
Mr. Mpofu.
Well, I wanted to deal with the question of the commission, but just because my learned friends were asked on it, but it's fine. I'll
hope, if you can only hope if there are questions, hopefully you can respond. But it doesn't look like there are any. So that will be the end of the matter. Thank you, Mr. Mpofu.
Going.
Going, Mr. Mpofu.
Going. Well, thank you, Justices. No, I know that I speak for all my learned friends when we are saying we are indebted to the court. And we also understand that we all have to be somewhere else just now. But and therefore any of the issues that I did not deal with in reply were covered in our heads as the court pleases. We're indebted to the court.
Thank you very much. Thank you to the colleagues. We need to consider this matter. We are aware of the time constraints. We are going to reserve our decision. I'm saying decision. And we are going to notify the parties as soon as possible as to whatever decision that we are going to take.
Yes.
But it's not going to be today. We can't do it now.
Justice, I understand, Justice Clark. If you just give me half a second. I can't remember what prayer it is, but in the notice of motion, we have catered, we do understand the matter is quite complex. So we made provisions for a situation where the court might reserve judgment. And I won't take it further than what is stated in the notice of motion and in the founding affidavit as to what interim measures could be taken. I'll just leave it in the hands of the court.
Reserves its decision. Court adjourns.
As court please.
You can't reply on the commission, they refuse to ask you questions.